Welcome to the first episode of 154 and Defense. I am Prakhar Bajpayee and today we shall discuss some of the complex sections of the new criminal law codes. I have specifically chosen these sections for our discussion today due to the limited debate and discourse surrounding the implications. The guest joining us today is Mr. Manu Sharma. He is a highly regarded criminal defense advocate with a distinguished 21 years of legal career. During the early stages of his career, he assisted legal luminaries such as late R.K. Naseem and late Mr. Ramjit Malani, shaping his expertise. His portfolio includes landmark cases like the 2G scam for A. Raja, the Fortis case for Malvendra Singh, the coal scam case, PMLA case for Om Prakash Chautala, former Chief Minister of Haryana, to name a few. Renowned for his unwavering commitment to justice, his legal legacy is characterized by integrity, an impressive track record, and an ongoing dedication to influencing legal narratives in the realm of criminal justice. We are honored to welcome you, sir, and thank you for joining us in the inaugural episode.
Thank you so much, Prakhar, for all the nice words and heavy words. I don't know if I deserve those, but thanks anyway.
So these three bills that create history have been passed unanimously.
Sir, the Parliament has passed the three criminal codes, namely Bharatiya Nyaya Sanhita, that seeks to replace Indian Penal Code, the Bharatiya Nagrik Suraksha Sanhita to replace CRPC, and the Bharatiya Sakshya that will be replacing Indian Evidence Act. So first things first, it is evident when you read the new codes that most of the provisions from IPC, CRPC, and Indian Evidence Act have been retained in the new codes with some tweaks here and there. The big
Correct.
question is whether introducing entirely new codes was truly necessary, or the same objectives could have been accomplished by making amendments to the existing laws.
Well, I mean, my personal opinion is that only amendments, if they were required, would have been sufficient, and there was no need to bring in three completely new pieces of legislations because according to me, and this is my personal view, and this view is also supported by literature and on law, the law must always possess an element of predictability and flexibility. And if the public at large is aware of the legal provisions, then they are put in a better position to comply with the same because we are guided by the old saying that ignorance of law is no excuse. So, over the past 150 odd years, while these pieces of legislations have been in existence and operation, I think most of general population is aware of the most fundamental provisions like 107, 151, the bonds that you have to file, what is 420 IPC, what is 302 IPC, under what section we go and get an FIR registered like 154. And it doesn't just apply to the general population, but it's also applicable to the police and the agencies and the justice system because they are well versed now by now. The jurisprudence is quite well settled. So, in addition to being a political move by naming it a certain way, I don't think in substance there is anything new. As you said, there is only rearrangement and very few. I mean, you can count on single digits anything new that has been brought in these. So, amendments would have sufficed. That's my personal take.
Sir, extending this further, the government has been claiming that these codes are Indian, and for the first time, our criminal justice system will be governed by laws made in Indian Parliament.
Hmm.
Ironically, CRPC, which is one of the act being repealed, was passed by Indian Parliament itself in 1973. So technically, they are repealing an act which was passed by the independent Indian Parliament.
तीनों कानून अंग्रेजों के जमाने से बनाए थे। जैसा मैंने कहा कि 150 साल पुराने कानून हैं। मोदी जी ने प्रधानमंत्री बनने के बाद गुलामी की मानसिकता और गुलामी के सारे चिन्ह इस देश में से जल्दी मिट जाए।
Yes, that's very interesting observation by you. In fact, when 1973 CRPC came into existence, it overhauled the 1898 Code of Criminal Procedure, and very lengthy and meaningful deliberations and discourse was undertaken in the parliament when 1973 code was brought into existence. So yes, yeah, among the three, this is a completely new legislation, and even the 1973 code largely, just like the present three acts, restated what was there in the 1898 code. There were few changes, of course, but largely it again was a reproduction. It's just the sections which were renamed. For instance, 342 CRPC became 313, and such like amendments. But largely it remained the same. Of course, whatever tweak was required, it was required to ensure that it was in conformity, because it was a procedural code. The procedural code was in complete conformity with Articles 20, 21, and 22 of the Constitution of India. So that was a requirement. But as far as IPC and Evidence Act are concerned, these have stood the test of time. On numerous occasions, Supreme Court and different high courts in the last 150 years have been called upon to interpret these sections of how evidence will be received or how a particular offense will be interpreted. What are the necessary ingredients? I don't think, and you would always see that whenever a need for overhaul is required, first of all, that need must be reflected in the judicial decisions. There, a need should be thrown open that we are not able to, or we are not in agreement with the law as it stands today, or there is a vacuum, so the parliament needs to come up with it. There has been no need shown by either the Supreme Court or different high courts in the last 150 years. So, as far as changing substantive offences law, the IPC, or evidence reception law like the Indian Evidence Act, according to me, there was no need, and that's why, if you analyze, you're right. I mean, there are very few substantive changes, and I mean, it's just like old wine in a new bottle. But yes, of course, if it serves the political requirement of awakening a sense of identity in the populace, yes, I mean, maybe it does serve that purpose. Nothing more, according to me, and I say this with great respect to the parliament which has passed these three acts.
Okay, sir. So moving ahead with our first bone of contention.
Hmm.
Under the BNS law, a new offense termed terrorist act has been included
Hmm.
under section 113. So,
Hmm.
this addition is significant because previously IPC did not cover any such offense. The concern
Hmm.
here is that the definition of a terrorist act in the BNS, which is a general statute, is taken verbatim from Unlawful Activities Prevention Act, which is a specialized statute. This
I
means that
agree.
the criteria for identifying what constitutes a terrorist act is directly borrowed from another legislation. But before going to the complexities, if you can first start by explaining the difference between special and general statute with keeping in focus UAP and IPC.
See, I mean, as far as need is concerned, there was no real need because when we have UAPA in force, and it has, as I said, I mean, it's been in existence since 1967 with a few additions here and there. It should have been left alone. It is well equipped. The definition under Section 3 and Section 15 are quite comprehensive. Terrorist Act is quite very, very elaborately defined. So there was no real need to bring it under the fold of Indian Penal Code. So, I mean, UAPA should have been left alone. There was no need for IPC to come up with its own definition, and it will throw open many complexities, like when IPC Terrorist Act should be invoked and when Unlawful Activities Prevention Act should be invoked. Unlawful Activity Prevention Act will be solely governed as far as investigation is concerned under the NIA Act, where there is a specialized agency to investigate, whereas IPC can be investigated by the state police. The next layer of complexity is all criminal laws under our constitution lie in the concurrent list. Once they lie under concurrent list, this kind of discretion is prone to that state legislature delegating and coming up with guidelines when to apply what, when to invoke, say, a UAPA, or when to invoke the new Indian Penal Code. Those guidelines may vary from state to state. I'm not even bringing in the element of discretion or politics into it. A set of bureaucrats in UP may interpret it differently than, say, in Madhya Pradesh or Karnataka or Kerala, without bringing the politics. And of course, if a particular set of facts have any kind of political undertones, then that discretion can creep into the realm of discrimination also. So ultimately, the citizen will suffer. Article 14 of equality, Article 2021, they will be compromised because of this confusion which is created. So it was a completely unnecessary act in bringing out a terrorist act under the fold of terrorist act. When a special act is there to take care of it, where is the need for it?
Sir, as you rightly said, India already has established frameworks, particularly through legislations like NIA and the UAPA, dedicated to handling terrorism-related activities. And
Yeah.
these frameworks already provide specialized procedures and power for dealing with such offenses. And
Mm.
even yesterday, when I was reading Parliament Standing Committee's report, there is no specific reason they have mentioned for adding this. I mean, the duplication of definition from UAPA to PNS. So, do you think there was any such need, or what do you think should was the intent uh, of the government behind this duplication?
As you said, I mean, I've tried to get into this question, but there is no clear answer, and that lack of clarity on this point will ultimately come to adversely impact its constitutional and fair and reasonable application. So I really don't understand. It's not, as you said, even the standing committee minutes are not making it very clear, and I also tried to dig in. So I'm not more. I mean, the question is where was the not the where was the need. The question is what will be the impact, and the impact is not going to be fair and reasonable. It's going to create confusion, and it is liable to misuse and abuse. That's the problem here.
So coming to the first implication of it, which I think would be the concern regarding the selective prosecution, because Section 113 of the BNS further mentions that whether to book a person under UAP or BNS would be decided by the police officer, not below the rank of superintendent of police. Now, which means that SP has his will to book a person either under BNS or under UAPA.
Mm.
The issue here is that there is no objective criteria or guidelines laid down to dictate SP's will
Yes.
to book the person in either of the statute. Now, now, what are your views on it? Do you think that there is any concern of selective prosecution by SP
It
in
could
absence of
happen.
any
Yes.
guideline?
Absolutely, it can happen, and see, Indian experiment with even giving these kind of powers. If you go back to Tata and Kota, and even Maharashtra Control of Organized Crimes Act. So when even a senior officers like a superintendent of police is conferred with that discretion, has not yielded any positive results. We day to day see Tata is gone, Pota is gone, they collapsed. Uh, Primarily for two reasons. Firstly, they were misused, and secondly, the element of a senior officer recording confession also was found to have been abused in huge number of cases. So, this discretion in the absence of objective guidelines, and now the area of discretion is much wider and more liable to abuse, will create difficulty. And if you go back to Supreme Court, as and when Supreme Court is called upon to comment on when executive must be left to come out with guidelines on how to apply a law, Supreme Court has always frowned upon too much delegation of legislative powers to executive. The the issue is simple. Parliament has been left alone to come out with what law is the need of the hour. Parliament must also disclose very clearly how to apply that law. The moment you leave it to an unqualified body like a police officer or an IS officer, and on when and when not to apply, the area of discretion becomes wider. And even in the absence, as I said, of any political undertone, two officers may vary on a similar set of facts. And that brings in the element of number one, vagueness, and the element of discrimination. And the element, executive discretion has to be guided in terms of constitution. Executive discretion cannot be allowed to run wild and free. I'm sorry to say, but the issue which has been created here, wherein an executive has been left to decide in the absence of clear guidelines when to apply UAP and when to apply the new Bharat BNS provision, is going to create a lot of difficulty. And in the years to come, in the months to come, we'll see a lot of litigation on this score. So yes, it's an area which should have been, if they wanted to come out, they should have come out with the objective guidelines and criteria also.
Okay, okay. So one more analogy which I was thinking could be drawn here. Uh, Consider a situation where there are riots between Group A and Group B in a particular state, and the Group A having an ideology similar to the state government. Now, the state police arrests parties from both the groups and books them under the terrorist-related activities. And because the
Right.
definition of what would constitute a terrorist act in both the acts are the same due to the duplication of definition, they are technically liable under both BNS and UAPA. Now,
Hmm.
in the absence of guidelines, it is the discretionary power, the will of that SP that would decide whether to book a person in either of that statute. Now, people
Yes.
from Group A being closer uh, uh, to the state government's ideology are booked under BNS, and because the SP has booked them under BNS, they stand the chance to easily get bail the very next day. Whereas people from Group B would be booked under UAPA, which is already an
Yeah.
infamous statute for its draconian arrest, custody, and bail
Hmm.
procedures, and they would languish in jails for years to come.
Hmm. No, you're right. I mean, you answered your question. I mean, that's where the clear set of guidelines was required, which has not been done, unfortunately. And you rightly said UAPA has a very tough bail provision, the twin conditions, which personally I'm dead against, because it should always be left to the court to decide when and when not to grant bail. So yes, bail will become difficult to people who are facing or slapped with UAPA, and bail may be relatively easier for people who are just facing a simple IPC and or BNS offense. And again, that discretion, if left open, is liable to be misused with or without politics. I say, I agree with you totally.
So, now, can there be a scope of simultaneous investigation by state police and NIA? Because consider a situation where SP using its discretionary power book a person under BNS, and as a result of falling under BNS, the state police starts investigating. Now, central government uses its power under NIA Act, and suo moto takes up the case and transfers it to the NIA for investigation. Now,
Hmm.
as a result, the state police is investigating the offense under BNS, and
Hmm.
NIA is investigating the offense under its power of NIA Act.
Yes.
Do you think there is a possibility of simultaneous investigations where the state police and NIA has jurisdiction to investigate the same offense?
Yes, and now you're getting to the meat of the matter. This will invariably happen when the central government and the state government are ruled by different parties. And Article 20 of the Constitution of India, which has three sub clauses, bars double investigation and double prosecution, what in common parlance is known as double jeopardy under Section 300 of the CRPC. Although that's a different application, but Double prosecution on a same set of facts is expressly barred. And you know what will happen in this such a situation would be, because special law always takes precedence over general law. In that fact situation, ultimately, if the issue of violation of Article 20 is raised by people facing prosecution, the courts will be inclined to allow the NIA, because it's a special legislation covering terrorist act, as which happens to be both in UAP as well as IPC, the Bharatiya Nyaya Sanhita, will be will be coming back to NIA. So it will create this collision course, especially when the politics of the two states are different, and the sufferer always is the person facing it.
So, yes, yes, sir. So, now moving ahead with another contention regarding the police custody. If Before we start with the concerns surrounding the issue of police custody, if you can explain the concept of default bail section 167 CRPC, that would be great
You
to
know,
set the background.
yeah, I mean, police. I mean, before we even get to the default bail, one must understand why the police custody matters, and why courts have always been on their guard against police custody. Prakhar, we are yet to come out as a society from the clutches of a mindset which is not particular to any race. It's just that whoever happens to be in power will use that power sometimes in violation of the manner in which it is supposed to be. Police custody has been under critical analysis and has been subjected to a minimum, not just by our system, which set the first 15 days as the maximum. Pick up any high court rules like Delhi High Court rules, chapter one chapter is only dedicated. Now, these are rules framed by judges of Delhi High Court. It has their seal of approval. Delhi High Court rules, complete chapter dedicated and divided into some 12 articles, only to say, make one point: please keep police custody to a minimum. Please give police custody in cases of real necessity. So, what is real necessity? What is minimum? Is something which has always been an area of concern. That's why first 24 hour is the first word that you use, that if within first 24 hours police custody does not yield the desired result, something which otherwise would not surface, it would be left open for a court to decide it. Because even within 24 hours and even post 24 hours, there is a possibility that a person will be subjected to something which will help in extracting confession from him. Because police custody, by its very nature, is harsh, it's coercive, and as long as we don't change as a society, the person exercising powers to have police custodial interrogation will be viewed with suspicion. So it may take another century or half a century. I don't know. I don't have the answer. But the system as it exists today discourages police custody. So when 24 hours are not enough, it's 24 hour to 15 days. If 15 days are not enough, some of the special legislations have gone into the realm of 30 days police custody. Tada and Pota failed. Tada and Pota failed. Magistrates need real reasons to grant police custody anything in excess of 24 hours. So that's the system that we are living in. Now, when there is a judicially drafted Delhi High Court rules and many High Court rules, when in the last 70 years you can pick up scores of judgment by Supreme Court, all making the same point, that police custody is a bane, it should be reduced to a minimum. Now, to in derogation of all that, to bring in an element that it can be stretched in pieces also to the first 90 days is again subjecting a person to unwarranted interrogation for the first 60 or 90 days. That also means indirectly that for that first 90 days, you will not get bail. So the door of getting bail is closed, because police custody for 15 days can be distributed to 60 or 90 days. So there again, you are imposing an embargo on a court to entertain a bail, because the police will say that we are yet to cross the milestone of 60 or 90 days, when we can at any time ask for 50 for police custody interrogation. So that area of bail is gone. And if the window of granting bail in the first 90 days is gone, then it is an oppressive legislation. So all these factors put together, that an extracted confession has been an area of concern. It's a red flag in increasing this 24-hour or 15-day. Then to stretch it to these elongated periods is oppressive, and it's going to be a subject matter of intense litigation in the days to come.
So essentially, what you're saying is when someone is arrested by the police, they can be held in police custody for up to 24 hours while the police investigates the case. Now, if the investigation is not finished within this time, the person must be brought before a magistrate. Now, the
Yes.
magistrate decides whether to, you know, uh, whether to allow the person to remain in police custody or be transferred to the judicial custody. Now, here is the important part. The accused can only be kept in the police custody for for 15 days in total, which
First.
can be granted in parts or as a whole for first 15 days itself.
Yes.
Now,
Yes.
after the first 15 days, if the investigation is still ongoing, the person can only be kept in the judicial custody and not the police custody. This was basically done, as you rightly pointed out, due to the unscrupulous and overzealous policeman, leading to custodial torture and deaths in the police custody. Now, under the first BNSS, which came in August, it said that the police custody can be extended to 60 or 90 days. Now, BNS second, which came out after lots of deliberation, uh, it said that the initial 15 days within which the police custody can be granted is now extended to initial 40 or 60 days from the date of
Yes.
arrest, which means
Yeah.
that now these 15 days of police custody, which was earlier being availed in first 15 days itself, can now be availed in first 40 or 60 days. However, I fail to understand the concern highlighted regarding this section because, despite the extension, the maximum time a magistrate can allow police custody remains 15 days, just like
Yes.
before. So, from which point of view the concern of human rights is arising?
You read any judgment from the Supreme Court or High Courts. Speedy investigation are the key words under Article 21. Speedy investigation, speedy trial, bail not jail, no custodial torture, no inducement, no threat. Now the longer you stretch a period of a possible police custody, the more antithetical it would be to the said Article 21. Now, I will not say any more, and I hope that as and when a particular High Court or the Honorable Supreme Court is called upon to interpret this new provision, where you can stretch it to the first 60 or 90 days, I hope they will strike it down, because that is the antithesis of judicial verdict, judicially drafted high rules. Police custody is minimum in this country, and we have not crossed as a society the barrier where it can be stretched or it can be made admissible. And it is more so in cases under special legislations. Now, if you apply these kind of provisions to, say, an offense under PMLA, there a statement made to an investigating officer has a degree of admissibility, has a degree to which it can be used against the maker, and it can be used against even the people who are your co-accused. Now, the longer you stretch it, the more likely it is that a person, just to have that momentary relief of that emotional and mental torture, will say or write things which will suit the agency. And if it goes on for 90 days, just imagine this 90 days. If one continues to believe that any day I could be picked up, what mental impact it will have. So yes, it's going to have a lot of problems. So I hope it's going to be struck down whenever the courts are called upon to do it.
So, but the judgment of the judgment of CBI versus Anupam Kulkarni is often referred to as the landmark judgment, which held that an accused cannot be detained in police custody after the lapse
Hmm.
of 15 days from the date of arrest. Now, recently, in the cases of Senthil Balaji versus the state and even CBI versus Vikash Mishra, the Supreme Court has questioned the interpretation of Anupam Kulkarni judgment and said that the existing position of not allowing the investigating agency to detain the accused in police custody beyond the initial period of 15 days from the date of arrest needed to be reviewed. Now, given the recent Supreme Court cases questioning the interpretation of the Anupam Kulkarni judgment, do you believe that now explicitly specifying in the code itself the number of days within which the police custody can be sought aims to establish a consistent timeline?
Yeah, I think in some manner it is a response by the Parliament that before Supreme Court actually reviews and reiterates, hopefully with what Anupam Kulkarni said, let's come out with a law. So then the whole exercise will become useless, and then the next exercise would be to then examine the constitutionality of the new provision. So yeah, I think it's a response that before the Supreme Court reiterates or revisits the point, whether for or against, then they come out with a piece of legislation. But as I said, that good, bad, or ugly, we have this now. Then my hope is that it will be struck down.
Okay, so now moving ahead with the offense of sedition. So while the BNS does not explicitly mention the term sedition, it introduces Section 152 under the chapter of offenses against the state, penalizing actions endangering the unity and integrity of India. Now, the
Hmm.
Home Minister has clarified in Parliament that this new provision aims to penalize offences of Deshdroh, that is to say, anti-national activities, rather than acts of Rajdroh, so to say, against the government. Now,
Hmm.
how do you foresee the implementation of this clause and whether the interplay of Rajdroh and Deshdroh would prevent the misuse of this clause?
राजद्रोह को देशद्रोह में बदलने का काम किया। पहले राजद्रोह की व्याख्या थी, मैं आगे डिटेल में बताऊंगा। राज से मतलब शासन था, भारत नहीं था। किसी भी राज्यकर्ता के खिलाफ कोई भी कुछ बोलता था तो इसके पर अपराध राजद्रोह का कानून लग जाता था। हमने व्यक्ति की जगह देश को रखा है। व्यक्ति की टीका ये लोकतंत्र का सबसे अच्छा लक्षण है और देश को नुकसान करने वाले को कभी बख्शना नहीं चाहिए। ये दृढ़ता भी इसमें है। राजद्रोह को इतने साल के बाद देशद्रोह में परिवर्तित करने का काम ये कानून करेगा।
Uh, yeah, on this point, I'm with the Parliament. That's my personal view. I think sedition of the new BNS does actually is better worded because it talks about secessionist activities, separatist activities, subversive activities, and they take care of any kind of rebellion which may be raised against the interest of of the Union of India, so to say. 124A in the past was found to have been misused because it talked about hatred or disaffection or contempt for the government. So I agree with the Honorable Home Minister that 152 BNS is more carefully worded, and it seems to address the exact question which ought to be addressed. That whenever there is a separatist activity, that is what the law should take care of, rather than someone writing a critical article about the government and then facing action under 124A. So I think that's a positive development by the government.
So now moving with a last contentious section, Section 69. Reg- Regarding this section, it is
Hmm.
commonly been referred to as "ab breakup karne pe lagega rape ka charge," which according to me is fundamentally wrong to boil it down that way.
Yes.
So,
Yes.
it is important to clarify that this section addresses cases where the consent for sexual intercourse was obtained by promising marriage, which was not honored
Hmm.
to. However, there are concerns regarding the potential misuse of this provision by women, if relationships do not culminate in marriage. While the accused may be acquitted eventually, the concern remains that the legal process itself can become a form of punishment in India. What are your views on it?
Well, every now and then one is called upon to appear in bail for such unfortunate individuals. The law is already being misused by disgruntled women who thought that a relationship will go all the way culminating into a marriage, but at some point of time, uh, the male member of that relationship decided that no, I don't wish to. I Consent is a complicated issue in a relationship. That's why if you pick up the list of judgments, the law laid down by both the Supreme Court and High Courts, once one notices that there was a real relationship which ultimately did not materialize, then courts are inclined towards both granting bail and on occasions even discharging accused. They don't even have to face trial. Misuse is already there, I'm telling you, in a huge variety of cases. Relationships gone wrong or under parental pressure. Once a relationship of a sexual nature becomes a matter of public knowledge, either the prosecutrix on her own or under parental pressure does take the route of filing case. There will be one odd case, of course, where consent would have been obtained under a false promise to actually marry the prosecutrix, but those are few and far between. Most of these are relationships gone wrong. So this old as well as the new act provision is liable to be misused, and the problem is, I'll tell you what, when any kind of law, whether it's a new law or an old law, is abused or misused, in those situations it lies on the courts to recommend action against abuse. When we see a criminal statute being abused by anyone, whether it's a provision like this that you're talking about, or say any misapplication of any criminal statute, you rightly observed the process is the punishment. You may ultimately get acquitted or discharged, but months and years may have passed. Long periods of incarceration may have been suffered. Whenever courts come to a fact situation like that, where there is a clear case of abuse of the law, I think the courts should now, it is time, should now start recommending action against people who initiate legal actions when it is not warranted. So, I mean, you can have 69 of the BNS or 376 read with Section 90 of the IPCA, where there's a fight between consent or non-consent. Issue is of abuse, and abuse is right. It has been going on even in the existing system, and abuse is bound to occur even in the new law. The redress lies in action by courts when that fact situation throws open a case where it's been abused. I mean, it's I've only read in the code the paper that a breakup करने पर लगेगा charge. ये तो पहले भी था. It was there already. It was happening even under the existing IPC. So as you said, it's a repackaging, but it remains the same, and the courts will have to come down heavily as and when that situation is thrown.
So now let's focus on determining the genuineness of the offender, that is, of the man itself. Let's consider a situation where a man initially wanted to marry his partner. They both have intercourse under this pretext that the relationship would eventually lead to marriage. Now,
Yeah.
1 year down the line, this man is faced with the typical Indian society problem where his parents are not agreeing for marriage because of caste, religion, or whatsoever reason, and being compelled by parents, the man decides to withdraw from the marriage. Although
Right.
this case happens to be the case of breach of trust and not the false promise of marriage, because to fall under the latter category, the man should have the ill intention from day one of that relationship. However, all
Yes.
these legal complexities are so difficult to prove in court. While individuals may have their moral and ethical inclinations to defend either of the party, what legal perspective should govern such situation according to you?
No, the legal perspective is well established by all the courts in India, the Honorable Supreme Court, all the high courts. They've largely, whenever even a remote chance of this kind of fact situation is thrown, courts have come to the rescue. So these have been interpreted very correctly. Uh, that it is misused, yeah, one can't do anything about it. But the legal perspective is quite well established. The moment the court comes to a conclusion that at the time when the sexual intercourse, the first or the second or the third, that intercourse took place between a complainant and an accused, at that time either the intention was good, that there was an existing relationship and that led to the consent, and there was no false promise to marry, or that there was a promise to marry, but that got vitiated because of unforeseen circumstances which arose in future. There are divorces. People get divorced after years of marriage. It doesn't mean that everything that happened before that divorce gets vitiated. Relationships work sometimes they don't work on their own or because of outside pressure. It could be the prosecutrix family, it could be the accused family. I mean, there's no straight jacket, but yes, courts have very liberally interpreted the false promise to marry allegations which are thrown from time to time. So there's a established jurisprudence on when is consent vitiated by a false promise to marry.
Okay, okay. So on that note, thank you so much for sharing your expertise and unique perspective with us. Your insights have enriched our conversation and provided our listeners with valuable takeaways. Thank you for being
Thank
part of this journey with us, and we look forward to having you back soon.
The enacting formula and the title are adopted. Shri Amit Shah to move that the bill be passed.
महोदय मैं प्रस्ताव करता हूं कि विधेयक को पारित किया जाए.
Motion moved that the bill be passed. The question is that the bill be passed. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it. The ayes have it. The ayes have it. The bill is passed.